Well, hello, I'm Janet Morano, the Executive Director of Priests for Life. Welcome to our program. Well, there is so much going on in the news. And, for me and Father Pavone, we've only dreamt about the fact that every day when we wake up, they're still talking about abortion. Of course, they're not talking about all the right information, at least in the secular media. But at least the topic is front and center right now. And why? Because of the Mississippi case. And of course, you hear that called the Dobbs case. And any moment now, we could hear the decision, which would really uphold the Mississippi law. But it looks like, based on that leaked document, the overturning of Roe v. Wade. And lots of people have lots and lots of questions. So we're going to answer many of your questions today. And joining me is a dear friend of mine and Father Pavone's. He's the general counsel here at Priests for Life. He's also co-founder and senior counsel for the American Freedom Law Center. Welcome, Robert Muise, to our program.
Hey, Janet, great to be with you as always.
Oh, great to have you too. Well, now, just so everyone understands, you are a constitutional law expert, correct?
Yes.
Basically, yes.
So. Yeah.
Okay. So when we get into our discussion, I'm going to start with the Mississippi law briefly, but the famous line that the other side tries to say, that there's a right to abortion in the Constitution. We're going to come back to that thought in a minute, all right? But this all started, and I always said, Robbie, we don't know what could overturn Roe. What's the silver bullet going to be? But here we have the Gestational Age Act. It was heard on December 1st. And what I want people to understand, because they're all talking about the Alito leaked document. But the case was heard on December 1st. But according to protocol, Robert, right, about a week later, the justices, don't they meet and they discuss what they heard in the oral arguments, and they kind of vote, don't they?
They do. They basically take a vote of where they're going to go on this, and then the majority, they decide. The Chief Justice, if he's in the majority, decides who gets to draft the opinion, and then the opinions get drafted. The main opinion gets drafted. It gets circulated, and other justices can chime in or prepare concurrences or prepare a dissent. And the draft, Alito obviously was the one that was selected to write the opinion of the majority, and that's the opinion that was leaked from the Supreme Court, and that's unprecedented with the leaking of this draft opinion. So by all accounts, and Chief Justice Roberts confirmed that in fact was the draft opinion. So it's not like some sham. He acknowledged that, and they have an investigation going on. So by all accounts, it appears that Dobbs is going to overrule Roe and Casey. And if you remember, the last time I was on your show, I think this was back when the case was even granted review, right. And we had this discussion. I said that when I looked at the question that they granted review, whether all restrictions on pre-viability abortions were necessarily unconstitutional. If you remember the conversation we had, I think Father Pavone joined us on the show as well. I was like, I don't see how they, number one, don't grant review of that question without knowing that there's a majority that wants to do something pretty dramatic. And number two, that dramatic thing being overturning Roe versus Wade. It just seemed to me way back when the cert was first granted, the nature of the question that review was granted on, there was something that big was going to happen. And it appears that is in fact going to take place. The opinions typically come out on Mondays. They try to get them out in June. So probably either next Monday or the following Monday. I somewhat ironically, if it comes out on the 27th, the Monday the 27th, I am lead counsel in a jury trial for 4 pro-life rescuers who are being prosecuted for trespassing and causing a disturbance and resisting officers because they passively resisted at an abortion center in Flint, Michigan. And we have a defense of others defense, and the only basis for arguing that that you couldn't have it in this particular context is Roe versus Wade. So it's kind of interesting that how these things are coming together at this time. So it's going to make for some interesting law going forward.
Right. All right. So let's just show them how the court's supposed to work, because what's bothering me, Robert, is in the media, the left and most of them are not even talking about, because what I told people when the whole thing first leaked, you should be upset whether you're pro-life or pro-abortion, because the very way our Supreme Court and all our courts have functioned for centuries has been under this sense of confidentiality, collegiality. Because, and I use of course, everyone points to the example of Ginsburg and Scalia, right? Polar opposites, right? On issues, not just abortion, on a whole host of issues. Yet they were best of friends. They would go out to dinner together, go to the opera together. And so there was always this sense of it was like the sacred halls, wasn't it, Robert, of the Supreme Court?
It's
right?
called civility. It's civility, right?
Right.
That's what we've lost, and it's the left that's that have totally. I mean, and your point about there's the courts have to operate in a certain way where there's confidentiality. They obviously when it comes time for the opinion to be issued, it's going to be issued, and it's going to be very public, and the public can respond to the opinion as they want to respond to it. But this was leaked purposefully, no question, so that what we're seeing transpire right now, to include these protests, even it appears an assassination attempt of Justice Kavanaugh and his family. Just whoever leaked this, I mean, there ought to be some serious punishment. And why is it? I think most conservatives think that nobody's going to be punished for this. They get away with this all the time. And even like, for example, here in Michigan, we have our election coming up in November, and now the pro aborts are trying to get on the ballot. They have to get a number of signatures to make it a constitutional right, because you can amend the Constitution in Michigan by a ballot initiative to get enough signatures. Well, this gave them a running start of several months before the opinion would eventually come out. And so all of this, I've said from the very beginning, Roe versus Wade was the worst decision. Not just because it legalized the killing of innocent human children, but it also has corrupted our entire judiciary. It had become the litmus test for whether a judge should or should not be on the bench. It's the reason why all that nonsense that went on with Bork, with Justice Thomas, with Justice Kavanaugh during their confirmation hearings. It all was centered around the issue of abortion. And it's plainly a litmus test for the left in terms of whether somebody should get on the bench or not get on the bench. And again, that's so corrupting to the entire judicial system. And it's so corrupting that we had even corruption in a way with the leaking of this opinion. It just shows how ugly and awful this whole abortion issue is, across the board.
Okay, so let's just take everybody the path here now. We said they voted around, December 8th, 9th, a week after the hearing. Obviously, the conservative voice won because Chief Justice had Alito, well, you write the opinion. You start working on the opinion. So what people have to understand, when that happens, it means Alito's clerks and Alito begin to write it. And then what I understand, Robin, is that I think first they circulated among the people who voted with them, right? The other conservatives, they passed it around, and people could circle like a paragraph and say, well, I'd like to change the wording here, or I'd like to add that. Isn't that what they do? It's kind of like it's a working document, isn't it?
That's my understanding as well. I never got to clerk on the U.S. Supreme Court. I've known plenty of people that have clerked on the Supreme Court, and that's a pretty standard, because it's a similar process in many ways in the circuit courts, where you have only three judges that might have you have an opinion that gets circulated around. The majority will look at it, because somebody in the majority say, well, look, I may want to add something in addition to it that that a majority of them don't want, and it turns into a concurrence, right? He might write a concurrence, look, I agree, and then might add some element to that. And then obviously you have the dissenters who will write a dissenting opinion. So because all that was leaked obviously was just Alito's the majority opinion. We don't know if there's going to be concurrences. There's no doubt going to be dissents, but we haven't seen the dissents yet. And just focus on the opinion. I mean, my goodness, that was a thorough, it was a scholarly and an intelligent takedown of Roe versus Wade. I mean, there's just no doubt about it. I mean, I think people will be studying that opinion for a long, long time. I believe it was 65 pages long. And it was thorough, it was exhaustive, and it just totally thrashed the Roe versus Wade. And quite frankly, Roe versus Wade wasn't grounded in any legal principles. It was just pure raw judicial power. And I think that was a quote in the the opinion as well. That's all that Roe versus Wade was. And
So
this, anyone who takes objection to, and quite frankly, all these protests and everything, how many of them have read that opinion, right?
no,
Of course they didn't, because for them, it's not about the law, it's not about logic, it's about pure power. And really, it's what they want the court to be is tyrannical. And that's what Roe versus Wade was. It was tyrannical. It took a very contentious issue from out of the political process and handed it to, just a majority of 9 justices to rule for the entire, country. And that's problematic in and of itself.
right. Well, none of them, Robert, read Roe v. Wade, and none of them, I'm sure, read the Alito opinion. Now, with the Alito opinion, would that also be circulated with the dissenters too ahead of time like this? Would it be passed around?
Yeah, it's because the dissenters have to start writing their dissents as well. And obviously the dissents, and if you've ever read dissents in the Supreme Court opinions, they obviously dissent and refer to the majority opinion. So they would have to be doing that right now.
They'd have to have privy to
they
it,
would.
right?
They would have to have it. The precise timing of that, again, not having clerked at the court and certainly not there on this particular circumstance, but that's generally the process. They go back, they vote. Somebody selected to be the majority writer, they draft the opinion. The opinion starts circulating for justices to make comments or to draft concurrences or to draft dissents. So there's and if your point you're getting to is it likely that one of the dissenting judges like Sotomayor, who no doubt was not on the majority of this, would it have circulated through her clerks? I think there's no question that would have been the case. That they all would have had an opportunity to see it. So to think that this somehow leaked out of the office of Kavanaugh or Roberts or Thomas, I think is highly unlikely, if not impossible. And it was likely somebody else that
I have my own theory, Robert.
Yeah.
Which I'll tell you at the end of the show.
Okay.
But let's just talk about Alito's draft. Because I haven't read the whole thing. I'm about halfway through because it's so intense.
It is.
But I noticed in the very beginning, that's where he talks about the Mississippi law, but it's almost like an afterthought. Like there's not much about it. He upholds it. But most of it is about Roe v. Wade. Isn't that correct?
It is, but he does in the latter part, when you continue reading, you'll see he does cover the Mississippi law, and he makes the point that, look, we're going to apply standard, constitutional evaluation principles for a law that doesn't burden a fundamental right, and that's rational basis, right? And rational basis is the lowest level of a review of a law, and he upholds it, and that's appropriately so, because he goes through the beginning part to make the point that Roe versus Wade and Casey have to be overturned. He goes through all the principles of stare decisis, goes through the Roe decision, the Casey decision, and really just he tears it apart intellectually and in so many different ways.
Okay, not everyone listening right now are lawyers.
Yes.
Could you explain to them, because that word stare decisis gets kicked around a lot. Could you kind of delve into it for the common non-legal people like me?
Right.
Boil it down, like what is he really saying in English?
Stare decisis, right? For a court to overrule one of its opinions, it obviously has to be serious consideration to do that. In consideration, because our concept, our legal system is set up with the concept of stare decisis, meaning that we rely on precedent, right? We rely on precedent for follow-on decisions, because if you didn't have precedent, you would have chaos, right? Because if every time you brought a case, it was looked at brand new or de novo, as we say in the law, there would be no way to predict any types of outcome. Right, even from an economic perspective, there would be no predictability of what is proper behavior, what's improper behavior, what violates this provision of the Constitution, what doesn't violate it. If we don't have precedent that we can rely on, then it's just chaotic. Because we don't have any predictability of the direction the law should go. But there are times when the precedent is just plainly wrong and it has to be overturned. Right, Brown versus Board of Education. Right? Everybody holds that up as is one of the greatest cases from the Supreme Court, and yet that had to reverse Plessy versus Ferguson, which held for the proposition that separate but equal did not violate any equal protection provision. And Brown versus Board of Education, blew that up And now we have, now schools aren't, we don't have segregated schools. We don't have segregated, lunch counters and that sort of thing. And all these Jim Crow laws and everything are gone. But it was important enough for the Supreme Court to do that. And again, Brown versus Board of Education is one of those cases. Roe versus Wade was horribly decided. It wasn't based on any, legal principles. You can't create fundamental rights out of whole cloth. The language that the courts use for determining whether there is a right under this, concept of substantive due process, which itself is kind of oxymoronic, right? Substantive due process, but we do have rights on the substantive due process, and it has to be, and this is what the language from the case is, deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. That's not the case with abortion. It never was the case. I mean, certainly prior to Roe, the vast majority of the states forbade abortion as a matter of law. There is no, history and tradition of recognizing abortion as any type of fundamental right. It was created out of whole cloth by a majority of the justices in the Supreme Court in 1973. It was bad precedent. It was a wrongly decided case, and unfortunately, it's taken this long to remedy that problem. And in the process, 60 million some odd babies were killed as a result.
Right.
But we're finally at that point, and
how
he
does
really went through the
Alito
opinion very thoroughly to do that.
So how does Alito pick it apart? Basically, what does he?
Oh gosh,
Well,
just
give a few for the layman. Just give a few little examples, a few little ones.
Well, like the main example is like I mentioned, is it deeply rooted in the nation's history and tradition that we have a history and tradition of abortion. Even at the time of the drafting of the Constitution, in our nation's history, and even in the history of common law or British law, it just did not exist. It was created out of whole cloth in 1973. That is one of the main principles for whether or not there should be a fundamental right recognized under substantive due process. And really, if you want to get to the heart of it, that was it. I mean, that's one of the main principles. And he goes through all the history, and you indicated you started reading it, all the history of this, and even the concept of stare decisis is an important concept, and you have to be very careful if you're going to overturn a prior precedent. But this is one that, as he pointed out, really called for it, because it hadn't become settled by the Supreme Court. If anything, it became further unsettled, in that this battle over the issue of abortion, at the Supreme Court, took it out of the hands of the people and the legislatures and so forth. And this is a prime example of where the Constitution doesn't speak to it. There's no basis in our history, in our traditions, in our common law, or in any other principles of law to create out of whole cloth this right to abortion and to undermine the entire democratic process, which will address this. It's and it's somewhat interesting. This one paragraph jumped out at me as I was, going through this again for the interview, in light of everything that we know that's going on around this. He says, quote, "We do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. And even if we could foresee what will happen, we would have no authority to let that knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives."
Perfect.
That sums it all up, and it sums it up in a way too. In some respects, when he made the point about we don't know how society is going to respond, I think he didn't expect it to respond to these these protests outside of his private residence and threats of assassination attempts on the other justice. I don't think that is what he had in mind. But what he said there really kind of sums it up in so many ways. The Constitution does not confer this right. It belongs to be decided by the people and the states, and they have the authority to regulate abortion how they see fit. As the way when you think about constitutional republic, that's the way it should be. Although there's some that would argue an unborn child should have a right to life under the equal protection. So they didn't go they didn't go that far, but they went so far to say it doesn't confer the right to abortion.
Right. Well, you know, Robin, recently I just last month a brand new book came out. Everything you need to know about abortion for teens. That's my newest book.
Yeah.
And in researching the book, I went back to see, when did we first get abortion? Like, how far back can I find a woman trying to terminate her pregnancy? Do you know, when I did my research, that the first recorded time in history where a woman tried to, with herbs and all jazz, to get rid of her pregnancy was all the way back, recorded in 1500 BC in Egypt. Imagine that.
Yeah.
Then I researched the United States a little bit. And in the colonial, when we had the 13 colonies, which, you would just refer to our founding fathers,
Yeah.
abortion basically was illegal in most of the colonies. There was only a handful that allowed it if the woman's life was in jeopardy, they said, and only to what they called quickening back then.
Right.
Because back then it was when the mom felt the baby stir in her womb, then you couldn't do anything about the pregnancy. You had to just go forward with it. But if those were just a couple of colonies, whereas most of the colonies, it was illegal. So
Yep.
when you say what was the will of the founding fathers, there you go. It was that we would be a pro-life nation,
Yeah, and that's the whole point. He went through that, and he went through that exhaustively, and in so many ways to address every one of those issues. And it's not rooted in our nation's history. And in fact, it's quite the opposite. And
Right.
you said Roe versus Wade, and I think it was even expressed, like I mentioned, I think multiple times in the opinion, was just raw judicial power. That's all
Yeah.
that was. And it was time. We at least I prayed. I know all of you prayed too, that someday we would reach this point. We're still waiting for the day. One of these Mondays coming up here in June. But and obviously with the overturning of Roe versus Wade doesn't mean there isn't work to do. In fact, there might even be more work to do, in the sense that we're going to be battling all of
In
these
the state.
issues locally in the states.
Right. Right.
That's the way it should
Well,
be.
Well, as I think of what Justice Thomas always said, that the Supreme Court has to stop being the medical review board for this country.
Yeah.
And it's about time to take it from out of the judicial branch of government, put it back in the legislature where it belongs. That's
Right.
what he had said. But
Yeah.
one more question I want to just explore, because first of all, a lot of people don't realize that January 22nd gave us Roe, but it also gave us Doe v. Bolton.
Right.
And Roe gave the right to, abortion. Doe made it for any reason or through pregnancy. Now, obviously, you overturn Casey, you overturn Roe. So some people asked me, and I'm assuming the answer is correct, well, then Doe goes too. Was there any mention of Doe in the 60 some
Yeah.
odd pages?
It was focused on Roe and Casey, because Casey reaffirmed the central holding of Roe, is the way they describe it. And it's, when you think about Doe v. Bolton, again, a lot of people forget that on the day Roe v. Wade was decided, Doe v. Bolton was decided. Roe set up this right to abortion, set up this trimester framework, had language about life and health of a mother, because it was this kind of sliding scale in some respects of the further along you went into the pregnancy, the greater the state's interest was in protecting the potential life, as it were. And then there's language about, well, that you can, at some point, they could regulate abortion so long as they continue to protect the life and health of a mother. And then Doe v. Bolton essentially said, life and health of a mother is anything you want it to be. So what Doe v. Bolton did was, it basically said, okay, you got your trimester framework, but in reality, we have abortion on demand through all 9 months of pregnancy. With the overturning of Roe, necessarily Doe has to go. Doe was based on a finding in Roe, even though they're the same day. It's subsequent. The finding of Roe that there was a right to abortion. Doe was a sort of highlighting or emphasizing a point in Roe, or expanding a point in Roe. So with Roe gone, the expansion of that point in Doe is necessarily gone. And if you think about it too, if you still had Doe versus Bolton as good law, then what Dobbs is doing is meaningless, because then you still have a right to abortion up to 9 months of pregnancy. So it necessarily has to go. The two principal cases, again, are Roe versus Wade and Casey versus Planned Parenthood, which was a 1992 decision where they thought Roe would be overruled, but that didn't happen. But here we are today, 2022, and hopefully Dobbs will do the work that should have happened many, many decades ago.
That's right. Well, I know for a fact we're not going to get a decision on Monday, June 20th. The reason being is the nation will be celebrating a federal holiday called Juneteenth now. So the court will not be in session. So we won't get decisions on Monday, June 20th. So who knows? It could be any day thereafter. Who knows? But just before we go, I'd like you to remind our people your website, how to be in touch, because I know your ministry, your law firm does an amazing job defending pro-lifers all over the country. And I have a hunch you're going to get busier with all these attacks. I think you're going to get busier. We might have to call you. So just tell them, Robert, how to be in touch.
Right. Well, American Freedom Law Center, our website, AmericanFreedomLawCenter.org is the best way to contact us and to learn about the work that we're doing. And I appreciate your being on the show with you. I really do.
Well, I always love having you, Robert, because the average person, they hear all these terms thrown around and they're not sure. And like I said, on the media, you cannot get the truth. But here's my little idea of who leaked the document, okay? And you tell me what you think. I do think it's Sotomayor, okay? I think it was one of her clerks. But what I think is, like in the movie A Few Good Men, she gave the code red. I think she gave them the nod to do it. That's my suspect. And the reason I'm saying that is, that's my suspect as to why we're not hearing who's being persecuted, prosecuted, or brought up for here's the leaker, because I think it might point back to her helping her clerk leak it, or told them in a conversation, or kind of, push them in that direction. I don't know. I could be wrong, but those are Janet's tea leaves.
All right. Well, obviously there's an investigation going on. I can't imagine that this is a very difficult thing to do, because in my understanding with these opinions, they are very well controlled. You got to sign in for them, sign out. When you're done, you got to shred them and everything. So there should be a chain of custody, as it were, for this document, and the number of hands that touched it is got to be very, very few.
Right.
So,
well, we'll pray Robert, let justice be done. Right.
Exactly. Yes.
Well, thanks for joining me today, and be safe out there as we pro-lifers go forward to victory. Okay.
Amen.
Amen. Well, brothers and sisters, thank you for joining me on the program today. And remember, brothers and sisters, we're in this to stay until every child is protected. Every child. So remember, there are some abortions only you can stop, and some lives only you can save. Tune in again next time. Thank you. God bless.